so we can definitely end on time. We bring this lecture to you each year because, of course, as all of you know, medical malpractice liability reform remains one of our legislative priorities. We continue to face a mounting legal crisis, and Georgia is listed among the nation's worst legal states. Bartley Miller is a partner at Sterling, Seacrest, and Pritchard, specializing in insurance solutions focusing on the healthcare industry. He earned a BA in Risk Management and Insurance from the University of Georgia's Terry College of Business and was named partner in 2010. During his time at UGA, Bartley was a starting offensive lineman and a 3-year letterman and was named to the All-SEC football team. Let's give a warm morning welcome to Bartley Miller as he gives us a presentation on an update on Georgia medical malpractice environment. Oh, and I forgot to say, I'm so sorry. Keisha Callan, you won an award yesterday. You can come pick up your prize.
All right, good morning. Wow. Leave it to the OBs to be up and ready to go. All right, well, thank y'all for having me. I'm sorry I haven't been here really all weekend, I guess. I have got kids playing youth sports, and Dad doesn't miss youth sports games. So I came down late last night, but I'm absolutely thrilled to be here. So this morning, y'all have heard this talk from me. I think this is 3 or 4 years running. I think we all know kind of where things are headed, or you are probably hearing about where things are headed in the medical professional liability insurance market in particular, but also really in our litigation environment here in the state. So this morning I'm going to do a couple things. Number one, I'm going to give you kind of the normal stats that you've seen about what's going on in the medical professional liability, or what I refer to as the MPL market. And I'll talk about the insurance market a little bit, but then really what I want to spend the majority of the time talking about is tort reform and some of the things that are going on in the state, the conversations that are being had. Kate and I both were at Medical Association of Georgia for a meeting last week, however I do that, with a focus group of representatives from hospitals, the insurance market, organizations like the Georgia OBGyn Society. Physicians were in the room talking about what we need to do as a medical community to fight within the legislature to get tort reform back into focus, because we need it in this state. So my point of the conversation towards the end of this presentation is really going to be more about educating you about the topic itself and some of the key terms. I think one of the challenges we have in this state is there's a lot of people that use these big terms, and the physician world doesn't really understand what those mean because they're really legal terms, right? And so what I want to do is kind of educate you on those so you know when people bring them up to you, you talk to colleagues, you talk to people under the Gold Dome, you know how to speak to those issues. Okay, so let's talk about the HPL or MPL market. So y'all have seen this slide before. The American Tort Reform Foundation has unfortunately named Georgia as the #1 judicial hellhole in the country for the 2nd year going, tied with the state of Pennsylvania. This is a list that we don't want to be on. The Plaintiffs' Bar, or the Trial Lawyers Association, would tell you that this is not accurate, right? That Georgia isn't as bad as what the American Tort Reform Foundation states it is. But really what the ATRF looks at is they look at not only what's going on as it relates to awards and trends, but they also look at what the law is, right? Are laws benefiting, or statutes benefiting the plaintiff, and thus being unfair to a defendant, and can you get a fair trial in the state of Georgia? And so it's much more than just, what's going on in the court system and the results that we see from a claim perspective. So you've seen this slide before. We talk a lot in the medical professional liability insurance market about frequency and severity of claims. This is the national trends, and you'll notice since the early 2000s, we have actually seen the number of paid claims drop across the U.S. For those of you that have been in practice for many years or were practicing, back into the 80s, you'll remember we've had numerous med mal crises in our country, one in the 70s, one in the 80s, and then a big one really in the early 2000s. And no shock here, right, that the number of paid claims have come down since the early 2000s. The red line there is the average paid indemnity, meaning how much is being paid on a per claim basis. And you can see that red line is spiking there from 2021, which those light blue bars in 2020 and 21 obviously represent COVID, which we would have naturally seen a drop in the number of paid claims because the courts were closed, or many of them were, for upwards of a year. But claim severity continues to increase. This is a trend that I think we'll continue to see. Medical inflation in and of itself, legal fees, et cetera, everything's going up in cost. And so we're going to see those rise. If we look at Georgia, Georgia's a different ballgame compared to the rest of the country. So if you look at the red line there, well, let me speak about frequency first. So since 2012, you can see that we're actually trending upward, right, in the number of paid claims. And so why is that important? So one of the biggest spends for the insurance companies is legal fees, right? That's where the majority of the money is spent in malpractice litigation, is on the defense attorneys, the experts, et cetera. Well, the more paid claims, the more claim activity in and of itself is going to drive additional expense, right? Which then ultimately gets passed through to who? You, right? Insurance companies don't eat that. They're in the business of making money. And then you see in the indemnity side, on a per defendant paid indemnity basis, you can see Georgia roughly about $200,000 higher on average per paid claim than the national average. Obviously alarming, and you can see these big spikes that you see in 2020. You see big spikes there in 2022. Probably one of the things of this chart that is most meaningful, so everybody understands that our last kind of big tort reform bill was passed in 2005. Well, if you go look at the average paid, right, you see we're a lot closer to that national average. And actually a year after, in 2006, what happened? We actually dropped below. I think that's a telltale sign, right? Just one indicator that it worked, right? Tort reform worked, the caps worked. Now, there's a lot of arguments to that, which we'll talk about a little bit here in a minute. Okay, so if we look at just obstetrical claims, you can see we're a little bit higher in Georgia. That's the red line compared to the yellow line of the national average. We're a little bit higher on average than the national average. You can see, though, 2021 there with a massive spike. And this kind of speaks to what's going on in the market with these just increasingly large verdicts that we're seeing, or shock losses that we're seeing, which I'll speak to in a second. Okay, so this is a shocking slide for me. I don't know if it is for you, but for claims or verdicts in excess of $10 million, since 2016, Georgia has had 33. And these are malpractice only. These aren't trucking claims, product liability claims. These are medical professional negligence claims. That's larger than 10 million. Now, obviously, we've had some bigger numbers than that, but to think about the fact that in this state we've had 33 of those since 2016 is really astonishing. That puts us now on the list with Illinois, New York, Florida, Pennsylvania. Those have always been known as some of the worst malpractice venues in the country. The other concerning part is if you look at our medical community, the ecosystem, how large our community is compared to the states of Illinois, New York, Florida, California. We're tiny, right? and we are in the top 3 on this list. Very concerning. You also see there almost $1 billion awarded just in those claims. That doesn't take into consideration all the other claims that have been paid. One of the questions I get a lot, especially from my North Georgia and South Georgia physician clients, is, well, this is all Atlanta risk, right? Kinda. So the majority of litigation, and I would say claim expenses, are definitely still being driven by metropolitan Atlanta. That said, I would argue pretty soundly now that Bibb County is the worst legal venue in the state of Georgia to be a physician. You can see here 7 verdicts over $10 million since 2016, and I would tell you a lot of those coming in the last 5 years. It's crazy what's going on there. The other one I want to point out is that Union right there. So this happened actually a couple weeks ago, maybe a month ago now. Union has been known as one of the most conservative venues in the state of Georgia, right? It's up in the northern part of the state. There was a I believe the number was $46 million verdict there against the physician, and well, it ended up being primarily at the hospital. But we were shocked. Now, there were some circumstances around that case, and you can go look at it. There's plenty of reports about it of why that case happened. There was an indictment on a physician. There was a bunch of things going on in the optics in that case. But what it shows you is that even the very, very conservative venue where we've never seen something like that, we're starting to see these numbers, which again is concerning. Okay, so the combined ratio, I've referenced this before in past talks, but the combined ratio is really how the insurance companies measure, one of the ways they measure their profitability. So if you take total expenses for the insurance companies, paying out claims, underwriting expenses, risk management, et cetera, and you compare that to the total premium that they take in, right? If it's over 100%, theoretically, they are losing money, right? Now, what that doesn't take into consideration is the investment income that they get on their assets, which are large. But why I show you this is, there's many that would say, because each insurer doesn't report this by state, there's many that would say that these MPL insurers are running as much as 125, 135, 145 in the state of Georgia right now. So that means for every dollar they're taking in, they're paying out 45 cents. Right, if they're running 145. Obviously, that math doesn't work long, and there's 2 reasons for that. And I think this is important for you guys to understand from a consumer perspective. So insurance companies, they can't just do whatever they want to do from a chart of what premium they charge, right? So they have 2 issues. Number one, they have to file their state, they file a state rate filing with the Georgia Department of Insurance, which outlines how they can price risk. Now, there are exceptions to all rate filings, but they have to follow that rate filing. And the state insurance department has a control on what those rates do, and we're going to talk about that here in a minute. But the other thing they have is regulators who are looking at them from a financial perspective. So if you are an insurance company and you have billions of dollars in capital, you can't just continually burn that capital over and over and over again. The regulators look at that and they say, well, you're not receiving enough premium, right, for the losses that you're paying out, and then it's a solvency issue. The state has an interest in that because if you were written with a standard malpractice insurer, so we can reference all the household names, which most of those are standard insurers, the state insolvency pool steps in the event the insurer goes under in bankruptcy. So the state's got an interest in making sure that insurance company remains solvent, right? And in this world, malpractice can change really quickly, right? I mean, this is part of what we're seeing right now, where we look back to 2005, 6, 7, 8, 9, and really I would argue from 2005 to really about 2015. This is the most money the MPL insurers have ever made in this industry, ever. It's been unbelievable. Well, it's now turning pretty quickly, right? And they're trying to catch up, and it's a challenge. So the other reason I share this slide is it shows the cyclical nature of this industry. A lot of the turns that you see here into additional profitability or back into the green and yellow, a lot of that has to do with legislative reform, right? It has to do with tort reform that move the needle to then create better performance. Okay, so I found this interesting. I actually came across this information the other day, but when we look at the total population of MPL insurance in Georgia, and we look at just total premium, right? How much direct written premium is there in this state? We've gone from 11th nationally back in 2016 to now 8th nationally. Well, these are big numbers we're talking about, right? Hundreds of millions of dollars. And to see that kind of shift and to see it so quickly and to see us spike since 2019, I think it speaks very clearly to the insurance market's concerns about our state, right? We're going to continue to see rising premiums. And when we start talking about tort reform, what we're worried about is pulling the Band-Aid off, right? Or the rubber band snapping, right? It's going to be a quick shift, and then we get into crisis mode. It would be great if we didn't get all the way to crisis mode like we have every time before. I do want to speak to something really not obstetrical related, GYN related. We have seen a pretty sharp change over the last 3 to 4 years in the risk profile of specialties that have historically been kind of benign. I'll give you a prime example, radiology. Radiology might be the worst performing specialty in the state, in Georgia, but also nationally. Why is that? There's a lot of reasons. I think, number one, I think we've seen EDs change. I think we've seen the way EDs are staffed change. I think the relationship between radiologists and emergency room physicians aren't as good as it once was. I think the same goes for the floor. With the hospitalist programs, and I think when you have consolidation of healthcare corporations, facilities, and now a really competitive environment for the staffing of those facilities, I think there's just some continuity that's we've gotten away from. I also tell my radiologists all the time that if every read is stat, no read stat, right? But we've gotten into this culture of we need it now and we got to get the study read. The volume that they are dealing with is incredible. I was talking to a radiology group that I've insured for 15 years, large one, and if we just look at kind of the work RVU values for them over the last really 5 to 6 years, it's just been astronomical how much more they're doing. I think it's only going to increase too. Right? I mean, the amount of imaging we're seeing just continues to elevate. Now, I do think there are things on the way. Everybody thinks of AI as this being this scary, not good thing for physicians. I actually think in radiology, it may actually be very helpful for them to at least prep a study for their review. But here's what I hate to tell you is as the OBGYNs, you are the prime target for litigation. You have a high severity rate, right? If you have a claim, obviously we have a brain damaged infant, right? Get ready for writing the check. And that's obviously always been the concern in this specialty. And then also frequency. And I'll talk more about that here in a minute. Okay, so to give you some examples of what's happened from a rate perspective, these are the average base rates. So remember I told you that all the standard MPL insurers are required to file base rates with the state insurance department in Georgia. These are the average base rates for the top 3 insurers in Georgia. And that is the Doctors Company, Curie, and MagMutual. Those are the top 3 from a market share perspective in Georgia. So if you look at on average between those 3, you can see that cumulatively, since 2017, rates are up about 64%. Now, I know all of you are sitting there and saying, I don't think my premium has gone up 64% in that time period, right? And that is true. So that base rate is the starting point, right? So all of the carriers, they file that base rate, and then off that base rate, they apply, loss-free credits or the GOGS program credit, right? So you qualify for additional discounts off that number, so it does vary how much discount the insurers are affording you under the policy or in their rating methodology. But this tells you that we're starting to see a continual trend now of what I would tell you every insurer in this state is going to try to get 10% a year. They're going to try to get 10% a year because that's what the Georgia Insurance Department is going to allow them to get. I can tell you the indications behind the scenes of what they need, according to the actuaries, could be as much as 35% per year. So this speaks to, we're going to see a trend upward in cost. And I hate to tell you that, but it's a reality. And I think we're starting to see that turn even sharper now. For GYN surgery, a little bit less, right? But a similar look at what base rate trends are doing. The other thing I want to mention too is we are starting to see insurers really look closely at territories in Georgia. For example, there is one insurer in Georgia that is now rating physicians in Bibb and Muskogee County differently than they would rate the rest of the state. Most of the insurers have been rating Metro Atlanta differently than they have the rest of the state, or the Northern Territory different than the rest of the state. But I think we're going to start to see these insurers evaluate territories and litigation environment in Georgia a little bit further. The state of Illinois, as an example, they might have 7 different territories. So I think that's something that's coming. All right. So talking about tort reform, I kind of want to open this up of what's the argument? And I want to give you kind of both sides of the aisle here, right? The medical community would say that most claims are frivolous, right? That, even if the patient was injured, right, that there was no harm as a result of medical negligence, right? And we'll talk about the facts here in a minute. We would maybe say the legal system is broken, right? Nuclear verdicts, it's getting out of control. We have runaway juries. Juries are making decisions based on sympathy for the patient and not facts, which, by the way, they are, which I'll speak to in a second. And that really the only way to fix the program is to reform the tort system or to have tort reform. The other side of the aisle, the trial lawyers, they would say, well, lawsuits are the only way to ensure reduction of medical errors, right? That there has to be a risk of financial punishment for physicians. I think a lot of people think about this often, and they can kind of understand maybe the big health system, right, and the target that's on their back. I think people often forget that you individually are liable. The individual physician is liable. I think that is missed a lot in the conversation. Talk about that again more. And they would say the medical system needs to be reformed, right? Not the legal system. It's the problem with the medical community, and that's why we're seeing these large verdicts. So who's right? Well, I know who's right. The problem is our politicians don't know who's right. So just a couple comments just for discussion purposes, I guess, would be, listen, 70 to 80%, and it depends on which study you read, and it also depends on the state, but 70 to 80% of malpractice lawsuits that are filed ultimately resolve to the benefit of the physician, often dismissed, right? And it often proves that, the alleged error didn't occur, right? So the argument from the trial lawyers, right, that there has to be this legal system and this punishment model, et cetera, well, 70 to 80% of the time, it's a waste of money because a medical error didn't occur, right? So improvements in patient safety and them arguing that, they have to have lawsuits, they have to have the ability to get these high awards, it's bogus in my opinion, because that's not the majority of the cases that we see. The other thing is bad outcomes, and this is probably one of the biggest issues in my opinion that we're seeing, especially in obstetrics. Bad outcomes do not mean medical negligence. It doesn't mean an error occurred, right? We live in this nature thing, right, that you guys can't control everything that happens with a patient, right, especially during a delivery. So unfortunately, the general public doesn't think that way, right? Often the general public thinks, oh, well, no, they can control, and they should control, and I should have a healthy child, right? I shouldn't have this complication. Just side note for my sake, because I talk about this with my clients all the time, I think this is one thing that in medicine, and this would be my encouragement to you, you can talk to your patients about things like this, right? I think one of the, maybe the biggest weapons you have as physicians is that your patients respect you, most respect you. And you can influence the way they think, right? Talk to them about this issue. Talk to them about your concern, and also tell them, hey, listen, I'm gonna do everything I possibly can, because you are, and you care about them, and you care about the result. I'm gonna do everything I can to protect you and to do the best I can to take care of you. But I can't control everything, right? It's the whole consent conversation, right? There are risks to everything. And you're gonna do everything you can, you're gonna fight like heck for them, but you can't control everything. And I think that's a message that really kind of speaks to this issue of what we see culturally on the topic. All right, sorry, this is a soapbox conversation for me, so I go off on a little bit of tangent. So there's a new script for trial lawyers, especially since the early 2000s of tort reform. We obviously saw more than half the states in the last med-mal crisis create some type of reform, litigation reform. And at that time, the Institute of Medicine estimated medical errors were causing 50,000 patient deaths a year, okay? Well, there are studies that the plaintiffs or the trial lawyers will argue that those deaths have now increased to almost 1 million deaths per year due to medical errors. Now, I think the number there would mean something like 2/3 of the people that leave a hospital or don't leave a hospital, die due to medical error. That's absolutely ridiculous. But what they point out in that is, see, you took away our ability, you protected physicians, you protected health systems, you took away risk for them, and now the medical system is less safe, right? The care that's being provided isn't as good. And what happened, what we told you was gonna happen is happening, right? And by the way, in the process, you took away our patients' rights for justice related to their injuries. That would be their argument. Well, I think one of the biggest challenges we have in the medical community is the messaging of how we respond to this. And I want everybody to think about this. I've always found this fascinating in medicine and working with physicians of how critical physicians typically are of themselves, right? And I think y'all are trained to be critical of yourself, right? And to correct problems. And I think as a medical community, that is almost promoted, right? There's a lot of times where we're almost telling on ourselves, right? These things aren't happening. Maternal mortality rates are up, things of that nature. We're almost proclaiming that we have a problem, right? Well, that falls right into the trial attorney's playbook, right? Because, even the medical community is saying that they have a problem. Now, we all know that that's a game, right? But I think we can very easily refute, right, that what the trial attorneys are saying, right? We can prove that medicine today is safer than it was 15 to 20 years ago, right? Outcomes are better, patient safety is better, our policies and procedures are better. Now, maybe not across the board, but overall, I think we can refute those, and I think we can refute it with actual real data. So the problem is we got to all get on the same page, have the same message, right? And they need to hear that, and our politicians need to hear that on a united front. So if we can refute those, why is this so challenging? Number one, the trial lawyers are extremely well organized. So talk about they're very, very well organized. They meet all the time, they party all the time, they are on the same page, and they bring a lot of money to the table, right? So remember, $50 million verdict, plaintiff attorney's getting 40% of that number, right? So that money moves pretty quick. I think one of the biggest issues is they're very well connected politically, right? And they've done a very good job of convincing politicians that their way of thinking and their rights for patients is the right line of thinking. What's the challenge with physicians in the broader medical community is, frankly, we are organized, but we're organized in a lot of different ways. And while we're putting a lot of money, especially the health systems, into our lobbying efforts, it's going to fight a lot of different issues, right? Reimbursements, CON laws for hospitals. It's going across the board. The trial lawyers are really laser focused on tort reform, right? Because they don't want to take away the piggy bank. So it's a challenge. And so one of the things that we have to do is we've got to encourage all of us to pull together. And I think I want to commend the Medical Association of Georgia. Them bringing this group together to have this conversation and to really get kind of all sides of the discussion going, I think is really good. But at the end of the day, I'm an insurance agent broker. Really what we need is physicians speaking this, right, and preaching this, because it's y'all's livelihoods and your risk. And frankly, I think from a heartstring standpoint, people can understand that. If we don't fix the problem, right, we are going to have an access to care issue in this state. We are already less competitive than the states around us, right? If you're an OBGYN and you see these litigation trends, why would I come work in the state of Georgia if I could go to North Carolina, right, and work? I think there's kind of sound, reasonable arguments for that, right? So we need messaging, we need better messaging, and we need to come together to fight this issue. All right, so this is more just education. I said I wanted to kind of talk about some of the bigger topics, and so you hear these phrases, I want you to understand what they mean. So from a negligence standpoint, each state or jurisdiction follows one of the following doctrines. The first one being contributory negligence, which is really what common law was. And what that means is if a plaintiff is even found 1% liable for the injury, right, injury to themselves, they can't recover damages against the defendant. So this is the case comes, I think it's Bitterworth was the case in Old England, where a guy was building his house and he left a pole in the middle of the dirt road, and a guy on his horse and buggy was speeding, which I guess you can do, hit the pole, and it killed the horse and injured the man, and he sued the homeowner, and they said, no, you were speeding and you were partially at fault. If you hadn't been speeding, right, you would have noticed the pole in the road. Okay, so that was the old law. Most states, so pure comparative negligence is if a plaintiff is 99% at fault, they could still go after the 1% at fault party, right? Which that doesn't make a lot of sense, right? Now, many states have moved to modified comparative negligence. And Georgia is one of those, where a plaintiff, if they are, and it's actually less than 50, not 51, sorry. If they are less than 50% liable, they can sue the defendant and seek damages. If they are more than 50% liable, they cannot seek damages. A lot of people don't know that, but that's in the Georgia law today. Okay, so this has been a hot topic, and I don't know if some of you may have saw what happened in 2022 on this issue, but there's a difference between joint and several liability and several liability. So let me explain. So if the total damages for a negligence claim were awarded at $10,000, and defendant A, and let's use the example of a hospital is named and a physician is named. If the hospital, the jury finds, the fact finder finds, that the hospital is 60% liable and defendant B, the physician, is 40% liable, under joint and several liability, which is the old way that we had it here in this state, either defendant could be required to pay the full $10,000. So the key point there is, if a defendant were to go bankrupt, so let's say defendant A were to go bankrupt in the process, defendant B would have to pay on behalf of themselves and whatever was apportioned to them, plus whatever was apportioned to defendant A, because they are joint and severally liable for the full verdict, okay? In Georgia now, we have several liability, and I'll talk about this more, but in our model today, if a plaintiff can only collect based on the amount apportioned to defendant A and the amount apportioned to defendant B. Well, we thought this was the case in Georgia because this was in the 2005 tort reform bill, but it didn't work out quite that way. So the 2005 bill created a couple things. Number one, it divided the previous law related to apportionment into two subsections, and that's important to consider as we get into the weeds here a little bit. It allowed apportionment to non-fault parties. So the example there would be if a plaintiff sued physician, hospital, and let's say they sued the orthopedic surgeon. If the defense during discovery finds out that, hey, it wasn't this orthopedic surgeon's fault, it was actually the radiologist's fault, right? Then the defense can file and ask that the jury, and they have to go through the notice process, they can ask the jury to consider the radiologist as an at-fault party, even though they are not a named party in the lawsuit, right? Let's say the statute of limitations has run, plaintiff attorney can't pull them in. So the defense then can point the finger at a party that's not involved in the case, right? And what we thought happened in 2005 is that the state had completely adopted several liability. Well, the challenge came down that there was the Hatcher case, which involved embezzlement of something like $2.2 million, and the injured party sued the individual that embezzled the money and the law firm that had provided some of the guidance related to the setup of the company, et cetera. And the bottom line is the one who embezzled money filed for bankruptcy and was gone. And they then, that happened very quickly. And so then the party that was damaged, the plaintiff, sued just the law firm. So there was a single defendant in that case. Well, even though the jury awarded like 99% of the fault against the one who embezzled the money, which makes sense, they then argued that no, the law only meant to create several liability in the event there are multiple named defendants in the same suit. But if there is only one named defendant in a suit, then joint and several liability still applies. So in that scenario, what the court said is we are going to allow joint and several liability, meaning that defendant B is now responsible for all of the verdict. And you, defendant B, can now go after the third party who is at fault to get recovery, right? Who, by the way, is bankrupt. So who loses, right? The defendant. So without going too much into the weeds here, the bottom line is the law, I think the legislators fully intended for several liability to apply. Because they broke up this previous written law into two subsections, the first subsection was, I want to say, poorly written, that allowed this, that required the Georgia Supreme Court to evaluate what the law is, and keep in mind this is part of the separation of powers, right? That the court has to look at the text, right? What the law says, not what they believe the legislators intended of the law. And so the Georgia courts did that, and they said in their opinion, even though we think that it probably was intended to be this, we've got to go by the text, and the text says that this should be joint and several. So all of that said, the big concern that we saw once this Hatcher case came along is that plaintiff attorneys started to game the system, right? So then, if you think about it, and this could work to the benefit of physicians and also to the detriment, who are they going to name as a sole defendant in a case? Maybe the hospital, right? The hospital's got one with a deep pocket, right? They're worried about collecting. So if they get a $45 million verdict, are they going to collect $45 million from a physician? No. There may be some of y'all, but I don't know many. They're not going to have success collecting $45 million from a physician, but could they collect it from a hospital? Absolutely, right? So then what it was is, okay, we're going to only name the hospital, right, and we're going to go after that deep pocket because now even if the physician is apportioned 99% of the case, right, you, hospital, are going to be on the hook for the whole thing, right? Well, the good news is House Bill 961 was signed into law in May of 2022, and it clarified this issue. You know, we were actually starting to see, we had multiple defendants in cases with physician groups, and we were going to have to see physician groups having to go after each other, you know, based on this law and this issue. So we think we're back to where we should have been. Okay. I got a few minutes left. So one of the big topics that's always talked about is phantom damages. Falls under the collateral source rule in Georgia. And for those that aren't aware, here's basically the issue we're talking about. When a plaintiff attorney goes in front of a jury in the state of Georgia, they are required to blackboard the retail medical expense, if you will, not the actual reimbursement amount, but the retail amount, the amount billed by the hospital, in front of the jury. So, in other words, they see that hospital bill and they see that Band-Aid costs $6, right? Well, did they get reimbursed $6? No, they didn't. This, to me, is a common sense discussion. It's a transparency discussion. In my opinion, it's a getting fair treatment and justice in our legal system, that a jury should hear what the actual out-of-pocket expenses are for a patient, what the actual reimbursement represents, and they shouldn't hear some phantom number, right? It doesn't make any sense that they would hear those figures. You as physicians are required to make decisions every day based on data, right? And you hope that data is accurate. Well, juries are making decisions every day in Georgia on information that is not accurate. And to me, that's wrong. And this is a common sense reform that we need to touch on. Now, there's a lot of argument. Florida had this in their most recent reform, and it's more of a complex discussion of how they're doing it. But at the end of the day, I think the state landed on, if we can't get a reasonable figure, it ends up being 125 of Medicare. Well, the plaintiff attorneys argue, well, these injured patients, they can't get care for 125% of Medicare. Nobody's going to take them, right? And so then they make the argument of access to care, right, for these injured patients, right? Now, we can all argue the spin, but I think there has to be some reasonable solution to that issue. And this is one that I think is going to be continually talked about. In fact, this is more of a discussion about evidence reform, really, at the end of the day. And I think there's a small group, as it relates to maybe this is another way we can attack a portion of tort reform, not making it tort reform this huge issue, and making it, or we need evidence reform, right, to touch on this issue. But this is one of the key points. The other one, and other states have done this, is limitation of fees for the plaintiff attorneys. So, and I think this is a hard one for the plaintiff attorneys to argue, or the trial lawyers to argue, frankly. You know, again, $40 million verdict, they're getting 40% of that number, right? Well, that's a heck of a lot of money. Well, who's not getting that 40%? The patient. Who was harmed? The patient, right? Not only are they getting paid that amount of money, but they also, in this state, which again doesn't make sense to me, they would argue, is in Georgia, if you offer to settle a case, defense or plaintiff, if you offer to settle a case and it is not accepted, it's rejected, and it has to be, I think, 90 days before trial and 60 days after receiving the complaint. If you make that offer, if the final award is 125% above what their offer was, what the plaintiff's offer was, the plaintiff attorney can then, after the verdict, come back and seek additional legal fees over and above that 40% cut. That's crazy to me. I had a $9.5 million verdict last year, and there was a very early on in the process offer, right, to settle the case. We hadn't even gotten through discovery yet, and we elected not to settle the case. I shouldn't say we. The insured and the insurer decided not to settle the case. And we ended up getting a $9.5 million verdict. Well, paid the $9.5 million, right? And then the plaintiff attorney comes after an additional $450,000 worth of legal fees. They just got 40% of $9.5 million, and now they're coming after an additional $450,000. At some level, we've got to cap what they're able to collect, and we've got to deal with the recoupment piece. Now, there is an argument that they would argue, all right, well, now you're on the other side, right? So if we make that settlement offer, they don't take it, and we end up paying less than 75%, right? We can go after legal fees, which very rarely happens because very rarely does the defense, offer to settle a case and it end up being less, right? But that's another issue. The cap on non-economic damages, obviously, if you look at just the data nationally and you see what meaningful tort reform is and where it's been impactful, there's been a cap on non-economic damages. Now, I want to make sure everybody's clear on this because this is talking to your patients too. So the cap on non-economic damages in 2005 that we had was $350,000. It is vitally important that we understand that that is not based on damages for the patient related to medical expenses, loss of earnings, the actual real damages that we can estimate or value. There is no cap on those, right? The only cap is the pain and suffering piece, right? The loss of consortium. That is what we're capping with those non-economic damages. So it's really important because I think if an American hears, wait, there's a cap on how much I can get, that's the legal system, right? We have those freedoms, and our system's always been set up that way. But it's very important to differentiate those. I want to bring up one piece, and I actually read a book here recently, and they talked about this, and I'd never thought about it, but in Georgia, we have a cap on punitive damages. So punitive damages are awarded when there's been willful action, right? Wanton, it's almost intentional action against harm against a party. Well, in the state of Georgia, we have a $250,000 cap right now for punitive damages. It does not apply to products liability claims, which everybody would say it should, but it doesn't. That's the Malibu Boats lawsuit from a couple years ago that was hundreds and hundreds of millions of dollars. The Ford lawsuit that you heard about that was, $1 billion in Muskogee County, the product liability claims. But the Georgia Supreme Court, that punitive damages cap has been upheld by the Georgia Supreme Court, and I think on multiple occasions. And I struggle to understand the difference between the two, right? Logic would say, well, the reason we deemed the cap for non-economic damages as unconstitutional is because it took away the patient's rightful or rights to seek full damages for their injury. Well, that could be the same argument on the punitive damages side. So I think it'll be interesting we see. Frankly, and there's people in this room like Skin back there who I see, who could speak to this. Do I think a cap is going to happen in this state anytime soon? No. That's just based on conversations I've had. Do we need it? 1,000%. And do we need to fight for it? Yes. Okay, another one that's talked about in Georgia is anchoring. So this is the concept of, and Georgia is one of the few states where this can be allowed, is a trial attorney can go in front of a jury and say, hey, what's this person's life worth? Is it worth $10 an hour for the rest of their life? Right? And then the jury is sitting there doing the math, right? 26 million. So the whole reason the trial attorneys are doing that is because they're trying to have the jury emotionally wrap their arms around damage, right? And not feel guilty about awarding $50 million because the attorney has given them a simple argument to tie the value of that case to something like $10 an hour for the rest of their life. We're one of the few states that allow that. And I frankly think it's driving some of these emotional verdicts we've seen. And I got to end here in a second. Just quick story. We had a case, $4.5 million verdict. My physician client did not do anything wrong in this case. In fact, it was one of the subsequent treating physicians who did. And the jury, after the case was over, we interviewed the jury foreperson. Jury foreperson said to us, you know, we didn't think your doctor did anything wrong, but we felt so bad for this patient, and the other doctor wasn't a defendant in the case. So we awarded $4.5 million. You want to talk about justice, right? That made me sick. And now, do we see that often? No, but that's as a physician, that would be one of my primary concerns of being in the courtroom, right? Okay, trial bifurcation, another big topic that's being talked about. And so really the concept here simply is to separate the trial into two different phases. The first phase of the trial is to determine negligence. Did the physician cause harm to this patient? Were they negligent in their care? Once that is determined by the jury, it then goes into phase two, which is the damages portion of the case. There were many, so North Carolina has this as an example. There are many that would argue that separating those two phases of trial removes some of the emotional, sympathetic response from a jury to a plaintiff, kind of like the example I just gave you, right? And so there's a lot that would say we need to bifurcate trials in the state of Georgia. So I can go on and on with other topics here, but I wanted to give you some food for thought, things that you can hear more about, learn more about, and discuss with your colleagues. So I'm just on behalf of GOGS. So we have a medical malpractice program, insurance program. Through the Georgia OBGyn Society, we've got now over $3 million of premium in the program. 1.5% of those premiums are going back to a benefit of GOGS for purposes just like this, of what we're talking about, tort reform, and the discussion there. We are not the sole provider of this program. You can call any TDC agent and get access to this, but we want you to know that it's there. Okay. We're done, but any questions? Sorry. Yeah.
Bartley, thank you. Excellent presentation. Can you explain to us what happens? I don't know the details of that $46 million verdict, but what happens when a physician suffers a loss that exceeds their coverage? So tell us what happens, but the other thing is, my understanding is that in the state of Georgia, there has not been a case where the physician's assets were directly attacked. If you could comment on that.
Yeah, so first of all, we also need reform on asset protection laws in the state of Georgia, because as a physician, there are very few ways that you can protect your assets. We're actually about to start an education program on that for our physician clients around asset protection. There's some things you can do. But Dr. Suarez, to your point, so very rarely are those types of verdicts collected against an individual physician. And the reason being is the plaintiff attorney understands that they don't want to go after those assets. They're difficult to gain. There's also a limitation to how much there is. What is happening in this market, and this is another issue for the malpractice insurers, is the plaintiff attorneys are really looking to go after the malpractice insurers for bad faith. And so what that means is if an insurer withheld what they would argue is a reasonable settlement and declined to pay it, remember you have consent to settle rights under your insurance policies, but you can't force your insurance to settle a case, insurer to settle a case. It doesn't work the other way. But if that insurer decides we're not gonna settle that case, takes it to trial, and then what are they doing? They're putting the physician's assets at risk. The plaintiff then actually turns around and really represents all parties back against the insurance company. That is a huge trend in Georgia right now, and it is not making the med-mal insurers happy. And unfortunately for us, we've got an in-house legal team, and the conversation with our in-house legal team all the time is evaluating those cases and what's going on for our physician clients, because to secure that bad faith argument, there needs to be a demand letter from the physician to the insurer demanding that they settle that case. And y'all can call me and I can give you more about that. But so to answer your question, that's typically what is happening. And then there are appeals and appeals and appeals and negotiations, and some of the cases that have been, there's been cases that are still around 7, 8 years from ago that had verdicts, still haven't been resolved.
Bartley, the assets of an individual physician been attacked in the state of Georgia?
No, not when it comes to taking homes and things of that nature. Now, have I seen physicians come out of pocket and stroke a check? Yes. But Barry, no.
Thank you for a wonderful presentation. Keisha
Sure.
Callens from Macon area. I did have just a quick question. I know we're almost out of time, but what can we learn from other states? I know that, for example, Florida has the NICA partnership, the Neurological Injury Compensation Association, and things of that sort. They've had new bills. So, what can we learn and what can we do? Because I feel like we have this information, but when I walk out of here,
Yep.
What can we do?
Yeah, that's a great question. So I think the point of this conversation we had at the Medical Association last week is very much centered around that, right? The messaging that we talked about, the getting everybody on the same page, frankly, changing the vernacular of this conversation. For example, phantom damages, we had this conversation at the meeting. When we say phantom damages, nobody understands really what that means. How about truth in damages? Right? That's a different spin. A little bit harder for the trial lawyers to argue that. So there are things that we're going to do. That's part of this effort, is to try to turn around and communicate this back to the medical community. It's something we're very passionate about. So that's the goal, to your very point. And I agree with you. That's the challenge for all of you as you walk out of here and you're like, okay, back to practice. Here we go. And this is a big and tough issue. So we need to do a better job of communicating it. Anybody else? All right, thank you all so much.